Hey, welcome to today's video. I'm Richard Chapo. I'm a internet lawyer down in San Diego, California. So today, just wanted to bring up some slightly good news on the CCPA in relation to methods for consumers to submit requests. So the CCPA is the California Consumer Privacy Act. It was passed in summer 2018. It goes into effect on January 1st, 2020, although actual enforcement of most of the provisions probably won't happen until closer to the summer 2020. But that's a subject for another day. So the CCPA was passed under very unique circumstances where basically it was rushed into law to avoid an initiative that was going to appear on the ballot in an election in 2018. And so it was a political compromise. And when you have that and everything's rushed, you end up with a law that's often not well written. And that was the case here. And so it has some provisions in it that are slightly annoying. Now, one is known as the email and phone number notice requirement. So basically, under the CCPA, consumers are going to be given quite a few rights that they haven't had before in relation to privacy and data collection. And so they're going to be able to contact online businesses and say, hey, what information do you have for me? What information have you collected from me? How are you using this information? Who have you shared this information with? These kinds of things. And so obviously they need to be able to make that request. And there were a lot of questions about how exactly that might work. And so the politicians, brainiacs that they are, included requirements that businesses must provide an email address and a toll-free phone number. Where consumers can go to contact the site in question and make their requests. Now, is that a huge burden and the end of the world for small businesses, particularly just small online businesses? No. It's just another little cost, another little annoyance. And for some reason, it's annoyed me ever since it's come out. And because if you think about something like a blog, okay, well, when was the last time you were in a blog that had a phone number? And why would we really need one? What about forums? All these different sites. Now, the bigger sites, the Netflixes of the world, or God forbid you try to get somebody on the phone at Google or eBay, that I can see. But requiring, blogs and things like that to have a toll-free phone number it's ludicrous. And so the good news is I wasn't the only one that thought it was a strange requirement. Assembly Bill 1564 was introduced to the California Assembly, and what it said basically was, look, either or. Provide an email address, an online electronic form, or a phone number. That's going to be fine. And that passed the Assembly. It then went to the Senate in California. And of course, the Senate had to screw with it because that's what the Senate does. But the good news is it passed in slightly tweaked form, but it did pass. And so we now have this bill, which looks like it's going to be presented to the governor for signature. Now, importantly, before I tell you what it says, this isn't law yet. And there's some suspicion that because there's so many bills in front of the legislature about the CCPA, the governor may hold off and just sign them all at once. So it might be a month or two. So don't take this as a done deal right now, but it looks like it will be signed. I don't know why he would reject it. This is hardly, a contested political issue. So what's the new requirement? The new requirement will say essentially that if you are an online business only, meaning you don't have retail stores or you're not a bank that also has, bank branches or something of that sort, then you can just use an email address only. So you would say to consumers in your California Consumer Privacy Notice, contact us at this email address, or you could probably even provide a form, to make your request. And you won't need the toll-free phone number. Hallelujah. Now you have to have a direct relationship with those consumers. So it needs to be your site or app where you're interacting with those consumers. If you, for instance, create plugins or something like that, and somebody uses them on one of their WordPress sites, you're not going to be allowed to just have an email address because you're not directly interacting with those consumers. Although, of course, this is one of the reasons people get frustrated with the law. There's no actual definition of what direct relationship is, but one would assume that that's going to be a little sketchy there because consumers not even going to know who you are. So in theory, you're going to need a California privacy protection notice on your site in which you provide both an email address and a phone number, because that's really going to accomplish a lot. I have no idea what they're thinking. But again, we're talking about the California legislature. When you get frustrated about the CCPA, just remember that this is the group that passed an anti-revenge porn law that excluded selfies. And if you don't realize why that is an incredibly stupid law, you should know that in revenge porn cases, approximately 80% of all those cases involve selfies. So they passed a law that didn't apply to 80% of the cases that they passed the law to prevent. Yeah, they're a smart group. So anyways, it is a silver lining. It's a small silver lining. Does it, get rid of the burden that small businesses face under the CCPA? No, but we'll take what we can get at this point. So anyways, if you have questions, comments, post them below. Otherwise, thanks for watching. Have yourself a good one.